His Excellency Rajiv Gandhi Central University, Itanagar, Arunachal Pradesh, Swami Ramanand Tirth Marathwada University, Nanded, Shivaji University, Kolhapur. These three universities launching these FTF programs, I am giving my well wishes to them. Professor Vinod Yadav has been taking an incisive pain to arrange these programs. His entire team, entire staff of the college, professor, associate professor, assistant professors and office bearers have been taking a much pain since long 3 months back, and today we are executing to it. Very nice. Well, these types of the habits now we want to develop through way of technology, that we impart the knowledge where it is to be required. Dear friends and fellow, my subject is today I want to deliver before you that post-independence of India and labor reforms. Labor is one factor of the productions, which is a active factors among the other remaining factors of the productions. Without the labors, it could not be possible that we can actively start any production process. As the day go ahead, as the day pass, as the decade backs, the importance of labor in the production system is remain as it is. But after some decades back, if we look into the history, we come to see that the accumulations of capital and importance of the capital tremendously increased, rather than the dignity of labor, status of labor, and justified to the laborers. So it is a long back pending the issues of labors and related the labor problems in developing countries like India. So labor reforms is a necessary, and it was necessary, and it should be a very necessary, because it is not a labor, but labor create a capitals. So it is a part of capital. So we want to give the dignity of labor very importantly. So it's important, we cannot forget. So far India is concerned that we see to the labors that labor reforms initiated in the British regime. It was started in 1820, and then it proceeded on continuously. Many times some changes has been taken place regarding the wages, times hours, using of machinery with the laborers, and with the production factor, capital and labor, use somewhere a capital intensive technology, labor intensive technology, and so on. Today that we have seen, when India became independent, it mentions especially in the constitutions that it is a constitutional obligations that we give the justice to the labor also. What is the justice to the labor? That labor is one factor of the production, and it is a human capital. Unless we are not giving the good importance to the human capital, it should not be possible that entire the human community we develop in such a way that we justify to all equally. So the constitution itself inculcate the labor and its the dignity and labor status. The constitutional arrangement has been made that the process of the labor, it should not be anyhow disregard, or it should not be that in a such position its value is to be underestimated. So since previous year backs, if we see that since slavery status till today, the labor factor is divided into the two parts. One is that organized worker who is in the organized sectors, and the other sector where the labor is working called the non-organized sectors. So far India, when we look toward the India, that to back history reveals to us that slavery and bonded labors. Slavery means when society emerged, it comes to see that the society gradually divided into two parts, one who has and one who has not, one who have and one who has not. Somebody became the owners of some accumulations with theirs to start the process of productions, and somebody who do not have anything, that why they remain without anything. So employer and employee relation has been started in the emerging society period. Employer giving a treatment to the whole employee that he is a owner and he give the any treatment, so the treatment should have to follow is the employee or his worker, and exploitation was there. And if exploitations was in the slavery system, then conflicts raise among the employer and employee later on, as the passage of the time has going on. As the time of the passage has been going on, naturally the situation of quarreling, situation of conflicting between these two has been always seen into the two process of the system that is called the employer and employee. So the constitutions of India says that the worker should have treated in very executive manner, that it's took care of its health, safety, then required training, then apprenticeships, fixations, and review of the revisions, and there the situation where worker is working in such a situation. So the contract labor, woman labor, child labor, and the other labor who is working in the process of productions or the process of any where they are working and giving the output to the employer, there should be reasonably and rationally should have been treated. So now coming days, the institutions have been formed according to the constitutions of India, that how it should be justified to the labor. So adjudications process that we have been beginning after the independence of India. So many the laws that we have been framed for it, so many the reform time to time that we have been taking place, and when somebody want to get the justify, somebody want to get the justice, the so many the institutions are working for the labor and for the justice. So the conciliation board, conciliating committee, the industrial tribunal, then central industrial tribunal, then labor court, and then industrial court. These are the institutions giving the justice to the court where the conflict or the quarreling is going on between the employer and employee. The principles of constitutions, like the doctrinaire, we say that the process of the directive principles. Directive of principle has given the direct rights to the state that they can intervene where it is to be necessary. So the principles of this doctrinaire of the directive principles have given a right to the any authority like state government and central government. So now in a nutshell that we are saying how protection after the slavery or the bonded labor that we are giving to our the labor sectors. Then what was the condition in the British regime? It is the historical perspective of labor laws. The evolution of industry was quite gradual during the hunting stage. So over the initial period that we have been as a human being developed, we were living in the hunting stage. then pastoral stage that we have been developed, and then agricultural stages were there. Then these three stages come up with the life of human being. In every stages, the rapport and approaches of human being has been changed time to times. And most important things in the British regime, when the British was in India, important thing was happened that in 70-20 to 70-50 to 80-20, the industrial revolution took place in England, and whole the pattern of the production system has been changed. Naturally, earlier the participation of labor with the production factors were in very high quantum. Later on, it became a mixing culture, labor with the technology. When the labor and technology comes together, then naturally there is some dispute arise. Because of unorganized sectors labor has not been any protections by the law. Even still, we say after the independence of India, after 1991, and when novel corona was developed, and millions of labor push back to their home and never try to pull back. So reverse migration when taken place, why it is happened, it should be a thing that we can think on it very seriously, because no any employer or any industrialist have given them the protection, even not pay the payment of 3 months, and when the pecuniary accumulation has been finished, they reverse backs. So it was a very serious condition in the month of April and May. It was to be noted in our history. And then in 70-20 to 80-50, the industrial revolution has been changed the entire aspect and entire scenario of industry, and mechanics and human capital going to work simultaneously. So industry has been developed very fastly in the European whole segment, and as industry development, the workers and employers or employee comes together. Both have been preserving their own interest. Employer has been preserving their interest, and the employee has been preserving their interest. So workman or the worker says that we want to more, we want to increase our the wages, and we want to have some additional benefit from our employer. And employer says that as according to the negotiation between these two, employer and employee, we will pay to you. So the additional benefit was not given at that time to the employee by the employer. So McMullen was the factory owner at that time, and McMullen come to the forward, though he was a factory owner. But in 1875, first time he was announced that he to be distributed to the bonus to the workers. And if he's distributed the bonus to the workers, naturally his capacity to thinking about the employee, so far it is thinks to others that how it is to be careful for the employee point of view by the employer. In the same time, the Bengali person, Shahapurji, the Sorabji Shahapurji had led the platform of the labor, and comes out of his office and says that unless there should not be a legislations for the labor continuously has been harassed, and it should be exploited time to time by the employer. So this initiative process we consider here, and it is a legacy of labor and labor situation in the British and pre-British era. When British comes to know these things, that it is now necessary that there should be some protection, and then we want to give some pay hit towards the labor and labor class. So the first commission before the independence of India, established by the British government, it's called the Royal Commission on Labours. Royal Commission on Labour was presided by V.H. Hitley. The chairperson was V.H. Hitley. And V.H. Hitley Commission was appointed in 29, and report has been 4th July 29, and a report has been submitted in 31. When Hitley produces reports, so many recommendations has been given by him, says that first, the security point of view, it is necessary. The social safety net, it is an urgent requirement for the protections of the labor. If security net is not to be provided, to the labor, the loss of human capital is to be there. And if loss of the human capital is there, then it could not be possible that we give the safe condition toward the labor market. So the protections of labor with health, to take care of the health, when we are talking the health not only to the male only, health care should be the female, health care of the children, health of the workers, those who are disabled but working in the factory, and there the efficiency. Efficiency always to be stored. If efficiency is not stored, then it should be a problem that how can he do the work without having a energy that has been creating among him that time to time. And if energy has not been creating by him, his efficiency should not be properly restored. And if efficiency is there continuously, that it is to be a part of when he is working into the production process, the productivity is to be a must. We are assessing the productivity by many way. There is the measurement system that what is the productivity, and there the scale in a particular factory. But about the productivity, when we are talking in pre-British era, there were in unorganized sector, the many workers were illiterate. They do not have at that time knowledge of the conduct of the production process. They do not have a knowledge that how can operate the machinery, and they do not have how can maintain the productivity scale. So far the output will get more and more by the employer. So it was a very basic problems at that time. So but there the honor and integrity with the process of their productions, they can work continuously with the employer. So it was generally a natural conditions in the pre-British era and justified by H.H. Whitley or the Royal Commission. And main recommendation he was given at that time, there should be a liaison officer. So labor officer should have to be a continuously work, and he is a continuous person taking a security towards the laborers. That's why the liaison officer or a continuing officer, and his establishment is to be there, so he can maintain the relation between these two, labor as well as the employer. If labor and employer is working continuously there, between liaison officer settle down some problem is creating between these two. So his main suggestion, his main recommendation of the Whitley Commission or the Royal Commission, that liaison officer anyhow to be appointed urgently and protect of the labor by all the way his education, his health, his efficiency and productivity. So that it was a recommendation pre-British era by the Royal Commission on labor. Then India was independent in 1947 and onwards. When we say first commission established in 1931, second commission of the labor has been established in 1966. Means after 35 years, non-organized employee want to wait who is justified to us, who is justified to them. Means after 35 years, again the independent government of India has been established, this National Commission of Labour, independent of India. This is the first commission in 1966, and it was headed by the Supreme Court Justice Gajendra Gadkar. Gajendra Gadkar has given some different recommendation in his report, and a report was published and it was given and handover to the central government. Central government has taken some step regarding as a finalize the resolutions to take the consideration for the welfare point of view of the reports. The first contents has been given in this report that social welfare or the labor welfare have to must. The same connections of the Royal Commissions on Labour, and when we see the National Commission on Labour in 1966 has been established, and first recommendation has given by the Gajendra Gadkar and his committee, said that the social security must to be there. Social security by all the means. Social security means not that only he comes to the at the spot of industry, and as he attend his house, that his social security is to be finished. No, social security means that You take the care of his housing, you take the care of his the education, you take the care of his health, you take the care of his the female worker, you take the care of the children worker, and you take the care of the mostly and giving the importance to the disabled worker, where if it is working in the the project or into the project units. So the Gajendra Gadkar and his committee has been specially emphasis that the welfare and welfare facilities are the rights of the labor. We cannot avoid the rights because it has been mentioned mandatorily in the constitutions of India and is the part of the directive principles of the India. So this is the process of recommendation has been handed over by this the process of this recommendation given by the committee to the government. So at that time the whole situation has been changed. Whole situation has been changed means then labor market has been established in the confined manner. The organized sector workers has been enjoying the different fringe benefit. Then unorganized sectors naturally after the adjudication part come into the existing like a labor laws, labor court, industrial court, labor tribunal, and this has been protected by so the entire situation means that the production system, production process, the awareness among the labor, the institution which has been imparting to them, and there the training, there the production quantum, how it is to be prepared, how it is to be packed, how it is to be released into the market, and how it is to be cost. That has to be this all the process. If we are considering that these all the things in this 35 year has been changed, because mainly because that we are the independent of India, and in the independent of India it was not effect of the British rule, and then we take the whole decision according to the situation and according to the welfare side of the labor. So when this all the thing is changed, this all the thing is inculcated in the report, and the report normally has been produced and submitted to the central government that the anyhow labor has to be protected by all the means. That should not be a harass. He should not be or she should not be hesitant. She should not be pressurized by employer, and anyone of employee should not be exploited by the employer. So the committee has been giving the most important that there should be a review, time to time has to be taken. Relations between the employer and employee should have to be taken continuously. So if review is to be there continuously, then next time what the review is to be with us, on the basis of this review, the next commission has to be given there the whole suggestion, and this should be the helpful to them. And if it is to be helpful to them, then we say that the unorganized sector workers have fully to be protected by as the changes of the time and so on. This was the mainly recommendation has been given by the first independent commission, National Commission on Labor, and he finally suggests that there should be a rationalization with the employee by the employer, rationalized relations, reasonable relation, and the rationalized and reasonable relation only to create an atmosphere and environment where in the such a fair and without fear atmosphere, it is to be a healthy situation to be enjoyed by the employer and employee. Then the second means first National Commission after the independence of India, or in the sequence, it is a second National Commission on Labor, that the rationalization of the existing reality in the labor in the organized sectors. So umbrella legislation must be there. So the divisions of labor, when we are thinking organized sector worker or the unorganized sectors of the worker, the organized sectors worker have a umbrella of legislation, and we have been enjoying that every after 10 years that you get the pay commission, but where the pay commission is available for the non-organized sector worker. So it is, I think that it is unjustified to them. because you are getting a more surplus by way of your the pecuniary gain when it is implemented the pay commission by the national authority or the state authority. But that small part goes into the pocket of the unorganized sector. So when at the one hand we say that there should be a healthy relations in the pecuniary platform, so one has to be more victimized because of inflation is there, because you have a more purchasing power, and second segment of your the society doesn't have that purchasing power, so he is remaining without house and without good education. So the first National Commission after the independence of India says that there should be a rationalizing between the unorganized sector and the organized sector. So judiciously they should be justified. So it was the great recommendation given by the Gajendra Gadkar, and says that after the 35 years technology has been jumped, and every industrial unit they want to save the labors and give the more and more preference to the technology. But in the country like of India, and when we are talking about that the country is the socialistic, after the globalization, this definition is now remain no any importance, but still we are not still we are not relieved over the principle of social justice and so on. So technology and the human capital work together, and intensive technology, so the intensive labor mixed with the capital, and intensive technology of the capital should have to use, and where it is to be needed, the labor should have to appoint and give to the optimum justified, so as the most of the human capital of the nation, because more than the 47 million people are working in the non-organized sectors, and non-organized sector, it is contributing in the GDP, I think that more than 50%. If the ratio of the in the GDP of the unorganized sector workers is more than 50%, so it must to have the right that they are equally get the dignity platform with the organized sectors labors also. So in such a way that we can develop our the labor reforms pre-British period, pre-British era, and then after British in the second National Commission on Labour, and then a third National Commission on Labour has been established in the regime of Atal Bihari Vajpayee, when Atal Bihari Vajpayee was the Prime Minister of India, and then the government has been decided that the National Commission on Labour has been needed, and on the chairpersons of Ravi Rajendra Verma, headed by the second National Commission on Labour after independence of India. At the time of 2002, the entire condition was changed, because we have been the part of the WTO, then we have to face to the problem of the globalization, or the entire state was independent, or entire state was a part of the liberalization, privatization and globalization. Industry were the free, and giving the independence and liberty to the capitals. So the process of the mechanism in the second National Commission on Labour, that Indian economy was free. If Indian economy was free, it means that the process of protections to the labor and status of capital was changed. In the WTO has a process that the capital should have to free. Means any capitalist make an investment anywhere. So if the capital get the more and more advantage by making an investment in any country, so naturally any investor should have to decide that make an investment in a particular country, so he get the more returns. When capital is free and WTO is not allowed to, labor is to be free. This is the complications of the WTO. Your capital is free, but your labor is not free. Your labor is free, but it is intellectual labor is free. Still you want to get the visa. Now visa's problem has been raised in the last month by Donald Trump. H1B1 visa was cancelled. So the very mercy condition was before us, that if the 7 lakh students come back to the India, where we should have to be accommodated to them. Then naturally, in the court, case was went into the court, and then after the court decision, Trump himself some repair in the law of H1B1 visa, and now intellectual labor working in the developed country where it is necessary. But non-organized sector worker has not been allowed to go anywhere. So it is a complication. If the capital is free, why should not labor is free? Why you are not giving to up to some extent to relief to them that they work where they require? But it has not happened. And in the liberalization and in the privatization, whole the employer is free. And as employer is free, there is no any restrictions depend upon them. Then how he is to be giving the treatment to their labor and so on. So you see the situation today. What is the situation regarding the employees going on in anywhere? No remaining today the trade union. Trade union has been finished. Only trade union now became a contesting with the government. It is a bank trade union only. No any trade union today we have to see. And if trade union is not protected by the employee, then who will protect to them? It is they became an orphan. All employees became an orphan. Bargaining power is finished. And if bargaining power is finished, the labor work is not being protected by any law. So in the second National Commission after the independence of India, Verma has been specially mentioned that though it is a condition of the free economy, but in the free economy it is an urgent requirement of the human capital. And human capital always require a protection. If there should not be a protections to the employee, then how your working class make a demand into the market tomorrow? If they are not making a demand into the market because they are not getting wages by protected way, so what should be the condition of your effective demand? And what should we have a next step that if effective demand should not be there, what should be the effect of the output of the industrial who raise the demand into the market? How many the export quantum that you can export? There should be some limitation. And when we are talking about the export quantum, if the any productions owner says that if the effective demand is not raised in any country, that we can sell this commodity into the international market. Do you have that competency? Do you have that compatibility with you? Do you have that type of the finishing which good is to be required or making a demand into the markets? These all the things has been now we want to think on it. So Verma says that in the 200 report. So labor should not a part of that thing that we can neglect to it. Finally, it is a national civilian. If the national civilian is not protected by the law and market protected by the law, so the imbalances should be there. If imbalances should be there, then there should not be we expecting in demand into the market that, and if market demand is not in the proportionate manner, then again we have a problems of the employment as well as the demand for the commodity. So he says that safety, housing, then education, and mainly he says that the insurance should have to be there. Unless insurance should not be provided by any employer to the employee, then additional burden he want to be bear. So at least he should be protected by the insurance scheme. So he have been suggested that insurance thing is very necessary. So the pre-British National Commission on Labour, first National Commission on Labour, second National Commission on Labour that we have been seen here. Then after the independence of India and as the National Commission, second National Commission has been passed, that what is the conditions and what is the law that we have been prepared. So it is an urgent matter that we can reveal these facts also. The various authorities have noted so far the recommendation has come by this all the National Commission on Labour that the influence of the formation of the post-independent labour and economic policy was priority given to government directed to nation building. Means if you want to prepare your nation and prepare the capacity buildings, so it is required that you should have to prepare the whole market, including labor, including capital, and including entrepreneurs and the lands. So these all the four things, it is must that simultaneously and equally they can develop in any nation. Then only nation have to proper develop the buildings. Then this report after the independence of India, and when we are go through the theories, then the development of labor law in India continue to follow a dual pattern already identified in support of the state plan and organized economy. The Indian government continue a strong intervention role in industrial relation. So when law comes into the existence, then it was very necessary that the relations between the employer and employee should have to be intact, and that be a contact. If it is a contact and intact, then only then we have to provide the protection and process of the protection that we can use for our the labor. The laws regulating the trade unions and industrial disputes remain largely fixed on the model set by the legislation introduced over the period of 1926 to 1947. The trade union law was firstly come into the existence of 1926, and the industrial dispute largely fixed by the model of this suggestion by the labor laws, that the industrial relations and the system with the union organization was legally sanctioned and collectively bargaining. So the trade union since 1926 to 1947, then the rights of the bargaining has to be given to the trade union. So the industrial dispute since 1926 to 1947, then again amendment has come into 1947, then onward the final things come to the 2001, how the trade union has make a good relations with their employee, and enactment of the 1926 Act 2047, then 2062, then 2067, then 72, then go on continuously, and finally 2001. So these are the things between the industrial dispute and trade union of the any company. This trade union giving the protections to the employee. So, but as I earlier said that in 1920, when 2001 to 1920, 20 years back, there is no National Commission on Labor, and between this the passage of the times, that everything is now vanishing. Everything is now go into dustbin. So employer enjoying according to the liberalizations of all the things, and private monopoly and their private monopoly powers they are using. And if they are using this all the thing, there should not be remaining any importance of the industrial dispute as well, trade unionisms of the powers. So bargaining power is now totally comes to the end. So the laws says that the Trade Union Act in 2001, it was provided that the trade unions were required at least have 100 members. If you want to install the trade union capacity to give the protections to the labor, it is a feasible condition is that there should be 100 workers, and 10% of the 100, there should be representations in the trade union as a member. So as the whole the legislations of the unions onerous had previously been the case. So these all the things has been taking place as per the changes in the law. The Maharashtra Recognitions of the Union and Preventions of Unfair Labor Practices Act 1971, which supplemented the Industrial Relation Act 1947. Means 1946 Act has been changed in the 1970. And 71 Act says that although that the legislation was limited in its applications to 9 industry only, in 1982, the Indian central government amended the Industrial Dispute Act of 1947. Between these two, where the provision was available in 1947 Act, it was amended in 1971, and 1971 Act has been again prepare with that mode on the basis of the Act of 1947. This is the legislation has been prepared for the amendment of the Industrial Dispute Act and so on. So this all the process where the reforms period or the after the independence of India, how labor reforms have been taken place. This is the example that we have been quoted here. The pursuant to the Industrial Dispute Act 1947, and there was the little limitations on the employer right to fire an employee as it saw fit. However, the pursuance of the amendment to the Industrial Dispute Act in 1953, 1976 and 1982 1972 and then later on the 2010. The central government began gradually to introduce the important new regulation pertaining to the retrenchment, layoff and plant and industry clusters. So in the 2001 Act, the government has been taking the considerations and giving the protection to the whole labor, that when retrenchment is going on, the retrenchment is according to the law, according to the rules and according to the government norms, and this retrenchment copy has to be submitted by the employer to the government or not. Government is watching this thing continuously or watching these things very carefully. Then the layoff process, why it is to be there, whether it is essential layoff, where it is because of the cost is increasing, that's why layoff is there, or the plant is now overburdenized. These all the thing has been taking place in the 2001 Act. So the any individual according to this Act, dismissals are the concern. A 1965 amendment, the Industrial Disputes Act, created a right an individual employee to notify industrial dispute. Means any personal employee is victimized by the retrenchment, so it has been protected by the 1965 Act that called the industrial dispute, and he has a right to go to the adjudication houses, just like a labor court, industrial court, and where the case has to be fit for the court and so on. So over his or her discharge, dismissal, retrenchment or other form of tremendous, whatever or not, the person was represented by the trade union. Means same times he want to make complaints to the trade union, so how it is to be justified and so on. So this is the act that we are getting so many times when the alone employee has been unjustified by the employer, by the trade union, industrial dispute relation, that has been come forwarded and solve the problems with the way of concessions. So the Industrial Dispute Amendment Act of 1982, in addition to declaring certain collective behaviors by both employers and unions to be unfair labor practices, declare certain hiring practices such as continuing employment workers or the casual or the temporary contracts with the object of the depriving of the status and privilege of the permanent worker. So there should not be any unfair practices between the employer and employee, and there should be a transparency between the relations of the employer and employee. So finally it should be a result oriented and give the satisfaction to the employee who is to be a worker there and so on. So the labor laws in India after the independence of India has been becoming in a very strong and transparent manner, and give the justice to the labor and worker, those who are working in a particular industrial unit and so on. So before the independence of India and after the independence of India and after the globalizations of India, there are the three phases that we have been seeing. That pre-British of India, there was not a problems of the employer and employee relation, because near about the situation were equal between the employer and employee, because of only he is the owner, but simultaneously he is also working with the employee. But in British era, when the technology has been developed fastly, then some distance created between these two, employer and employee. So law was necessary, law was framing after the recommendations of the H.H. Whitley Commission or the Lyer Commission. And the post-independent of India, the National Commission of Labour has been appointed in 1966, and he has been giving the very widely protection by all the means to the labour. And then second National Commission on Labour in the chairpersons of the Burma. So after the globalization, the commission was, second National Commission Labour was appointed. But this, all the conflicts comes together. The economy was free, the trade was free, and you are allowed the capital in the nation. When you are allowed the capital in your nation, and the international competition is raised to sell the commodity into the international market, and when these approaches comes before any industrialist or any producers, then producers always think that there should be a peace in industry, there should not be a quarrel in industry, there should not be a dispute in industry, and work process is going on continuously without any break. If this system is developed after the globalization, where the economy is free, then it has been affected. And so many the policy also, when we are thinking about, take the example of banking, take the example of insurance. Now government thinking about the general insurance company also merged to each one. The nationalized bank also merging. Now some 4 banks are also on the stage that they should be a merge and so on. So where is the interest of the labor? When we are going in the details and see this all the things, then some informations come before us that some part of the labor somewhere by the policy framework or the policy documents somewhere now it is in the positions that the labor make a more competitive, and he should be addressed with the capital, the producer expectation. So the producer expectation means that he is exploited to the laborers, and in very little cost he want to get the more and more profit. This situation is arise before us. So many the laws is there, so many laws is appointed, so many laws is amended after the independence of India. Reforms are there, but what is the use of these all reforms when this complicated and complex situation raising before us? Take example of the fraternity. So many the posts are vacated, but the process is that on the clock hour basis or part time the faculty that we are appointed. Is it in the system that you are appointed somewhere who are imparting the knowledge to some student? Is the status is the clock hour basis, or his status is the part-time basis lecturer or the teachers? So many the teacher posts are vacant. Who create the tomorrow a great good manpower to the nation? If great good manpower not prepared by the teacher, who make invention tomorrow? If invention is not tomorrow become a very proper manner, what is the system that you develop for the research wing? If research wing is not depend on the very qualitative the man force, how can you get the patent? If you are not get the patent, how can you sell the commodity in the international market without the competition? These all things comes in together. So the laws are more, but how we are giving the shape to this law, this is the more important. So we say that the in 1953, this is the pre-independent of India, the Worker Compensation Act was there. So according to the act, if any person has been injured when he was working in the factory, when he was working in the production unit, when he was working according to the scheduled time in a particular period, in a particular duration, and if he is hazard, if he is injured, if the accident has taken place, whatever the amounts come for the cost to repair to him or to get the relief from him from this accident or the any injury, that cost to be bear by the employer. So the act enacted the protection of the trade union. The law was amended in 2001. So the trade union has been interfering in it, and law was enacted of the 1923 in 2001 and so on. Then Payment of Wage Act of 1936. The Payment of Wage Act regulates by when wage distributed employer. Means if you are it is now typically we say that the organized worker. If you are working in the organized sectors, and the payment of wage act is there. So first you want to follow how much your the salary, and after the deductions of your the income tax or your the professional tax, you will get the amount. So for that point of view, you want to give the income tax properly, and your the salary which is cross the limit of income tax slab and so on, so you are entitled to make a payment, and it should have a right to employer to deduct that amount and to give a net salary to you. Then Industrial Employment Act of 1946. This act is also important that their orders aim to remove the flexibility from the employer in terms of job, hours, timing, leave grant, productivity measures. It was in favor of the employer. Some situation is arise there, and if situation is not allowed to the employer, that if anyhow it is to be naturally justified, or according to the act it is to be a justice to the employer. So this all the part of the act has to be followed and have a right to the employer that he must have to follow industrial employment standing orders according to the 1947 Act and so on. So the Industrial Dispute Act intervened into this process and says that the Industrial Dispute Act 1947 regulates how employers may address industrial dispute such as lockouts, layoff, retrenchment. It controls the lawful process for reconciliation, adjudications and labor. This process should have to adopt. When employer takes this decision, then employer should not have the injustice to the labor and so on. The Industrial Dispute Committee and Industrial Dispute Settlement Act or through the Trade Union Act have to settle these cases, and if it is not settled, the process of adjudication is to be started. Then Minimum Wage Act, the Minimum Wage Act first time has been implemented in India in 1811. Then it has been amendment in 1826, mean British period. Then it is in 1882. And then after the technology or the industrial revolution take place in England, at that time also the Minimum Wage Act is changed. And then after the independence of India in 1948, the Minimum Wage Act has been changed. The minimum wage, how it is to be there? It is to be decided by the two authority, one central government as well as the state government. If central government and state government has the authority to decide the Minimum Wage Act, it is to be a part of the inflation. It is to be a part of the demand supply analysis into the market. It is to be a part of how the social status of employee in any region, and it is to be a part of male and female or the children worker or the worker who is disabled. So still there is a guidelines how it is to be Minimum Wage Act. It is minimum to be 147 and maximum to be 1120 rupees. Just like take example of Manrega. Manrega Act has been prepared and it has been implemented after 2004. That in 2004, according to the Manrega Act, the government has been decided that under the Manrega Act, who is working in the process of Manrega Act, he is getting the such types of the remuneration. I think that like 260 or 270, I don't know exactly, but the remuneration has been increasing after the novel coronavirus, and its budgetary allocation has also increased by the present government to satisfy and mitigate the expenditure of Manrega and so on. So the next act is Industrial Regulations Act of 1951. The law declared numerous key manufacturing industry under the first schedule. It placed many industry under the common central government regulation in addition to whatever laws state government enact. It resolved more than 60 countries. So it should be a common law. So particular industry should not be a domain of a particular law. So it clutches the 600 industrial units, and the law is implicated simultaneously. These 600 industrial outputs or the industrial units, the same law is applicable to theirs. Then the Employee Provident Fund or Miscellaneous Provision Act in 1952. This act is giving the security to the workers. Now we have a practical examination. After our payment, we have been deducted the PF amount, means provident fund amount, because after your retirement you give the protection sum by your pecuniary platforms. This pecuniary platform is nothing but a provisions of the provident fund. It is Act of the 1952. This amount is payable to the employee after the retirement and could also be withdrawn partly to certain specified purpose. Suppose that in the durations of your working conditions, you have a problem of build your house, you have a problem of do the marriage of your daughter and son, if you want to wedding ceremony, arrange the wedding ceremony of your daughter and son, you want to withdraw this amount and so on. So it is necessary that he has a right, that he can get his amount, what the deposited is the PF account and so on. Then Maternity Benefit Act, it is a specially act made by the authority to give the protections to the male. After the marriage, it is necessary that maternity home is to be applicable to them. So earlier it was a condition of the 3 months you get the maternity benefit, but now present government has extended this time period of 3 months extended up to the 6 months and so on. So the salary is going on continuously, but leave is also giving by the present government to the 6 months and so on. Then Payment and Gratuity Act 1972. It was earlier in the British period, Payment and Gratuity Act. Now it is amendment in the 1971. If your service has been completed and if you are the PF amount that you get, simultaneously gratuity amount that you also entitled to get this amount. It is amount according to the 15 days of your salary till you are the end of your service. So whatever the amounts comes of this, the 15 years calculations with the whole salary of the month, with the end of your tenure of the service, or the 10 lakh rupees, which is to be a minimum. If it is more than 10 lakh rupees, then it is minimum of the 10 lakh rupees. If it is less than 10 lakh rupees, then it is to be justified to you the 10 lakh rupees and so on. So this is the law comes into the existence and the give the more and security and benefit to the employee. Then Contract Labor Act, it is a very complicated labor laws, 1970. The many times the post has not been advertised, the post has not been fulfilled after the 10 year, 15 year, 20 years. Even in the Supreme Court, the Chief Justice of India, Mr. Thakur, has been explained before the Prime Minister. So many the posts are vacant in the Supreme Court, it is not still fulfilled, and so many the cases are pending in the Supreme Court. It is the situations of the Supreme Court. What should we be talking about the you are the college institute, you are the research institute, or you are the middle school, or you are the primary school, or you are the revenue officers or income tax officer. Everywhere the condition is same. So what we fulfill our the need, that we can hire the person from the outside without any providing the nature of discipline. So he comes together and he also doing the work. After 30 days you give the notice to him. As accumulation his service, 2 year, 3 year, 4 year, and then he can try to make a demand that he should have to continue into the same job. But institution will not listen his language, and institute say that no, we should not have to make a permanent job available to you. So it is a temporary job. When post has been recognized, post has been identified, post has been giving some protections of the payment, and then we will give the regular services to you. So in that case, the Supreme Court has given the verdictions that the imbibe of the worker who is working on the temporary nature is not possibly adjusted and imbibed in the service text. So if he is accommodated into the service, then what should be the law which we have been framing for the recruitment? If recruitment law is there, and if you want to follow it, and some causes that you are set aside the regular recruitment, and on the clock hour basis or the part time or the irregular basis that you are appointed someone for 1 month or 2 months, So its right is not there. He can make a demand that he should have to make accommodate in a particular service and so on. It is a very gigantic decision has been given by the Supreme Court. I think that it was decision comes for the Madras case. Madras government has been recruited in particular department, and after 20 years they are the rendering of the services. The Madras Public Service Commission says that they were appointed on the temporary basis. Still, after the 20 years, there the nature of service is temporary, so they should have to immediately terminated from their service. But only right is there. If there is age is bar, still you call to them for their interview. Where the selection is to be there or not, that is a very different thing. So this is the law of nature. When we are talking about the employee and their the safety and their the protection, and if some mistake is coming from the authority and not recruitment made by time to time, this type of the system is emerging everywhere in India, in everywhere the department, and every department is now running on the basis of that the temporary or ad hoc basis person, and the ad hoc basis person is now somewhere the entire in charge of that offices. It is not my the sentence, it is a sentence of B.B. Bhattacharya, JNU the directors. He says that Jawaharlal Nehru University, in one conferences I met him, and in his speech he says that when I am come out from my cabin and asked to someone which research is going on the table, he says, he replied, Ms. Banerjee replied, said that no sir, I am not going to the research, but I am preparing that I want to teaching in somewhere colleges. So what is the research condition in India? If like a academic discipline, regular workers of the regular academic discipline, the teachers or the assistant teachers is not recruited properly time to time, who is imparting tomorrow to the students? How we prepare the good human capital in the nation? If we are not proper the good human capital of the nation, after not 2 days, after 20 years, what will be the answer before us? And how we solve these questions? So this is the very, I think that it is a very serious thing, and we want to take the cognizance by the regular recruitment and give the protections to the new generation, and give the guarantee to them that the once he appointed that their job is protected. So we can then stable our the economy. The last part of our the talking is that I am now not going to the welfare. These three commissions says that the welfare should have to be there, and welfare is only the rights of the employee. But same times, employee also want to give the same response. What is their the duty? How he is discharging their the responsibility, discharging their the duty with the full responsibility, and how they are maintaining their relation between the employer and employee. Now I am comes to the conclusions that the after the China is an emerging country now. He is a very taking the leading part into the international market and so on. So first time the China has been using the hire and fire policy for the labor. Whenever he required, he called to the labor, and when he do not want to workers need, then worker is go away, or worker do not have a need, so since tomorrow he will not attend the jobs. If a hire and fire policy that you use, then you are the international market, and what you are exporting to the international market, if there the demand is slash of the Chinese commodity into the international market, and domestic driven market is to be started, without your the domestic driven market, unless you are not depend upon it, so how your the effective demand is to be remain there? If there the worker is not getting a good job, there is no security, there is no trust, there is no faith, there is no resilience according to your the subject. If there is no resilience, if there is no any confidence to the laborers because of hire and fire policy that you have been adopted, we should not give the enough justice to our the population. If you are not justice to your the population, and population is the sovereign of your the nation, then I think that we want to seriously think on it. Labor reforms are there, but problem is that how much that we are implemented, and after the globalization and we are part of the liberal economy, it is necessary you want to take care of this all the production factors simultaneously. You want to protect the capital, you want to protect your the labor, you want to protect your the entrepreneurs also. Give them a more and more relief, so he is encouraging to make a good and qualitative jobs. So he gets the good demand into the international market. So we may not giving the bias to anyone. You give the same right and equal right to all. So on the basis of equal right, that we are equally justified to all. So H. Ramanujan says that you are the labor, society and capital adjusted themselves at the same platform. The society should enjoy more and more in the nation. Thank you very much.